Good evening, sister.
Good evening, Shamnama.
Good evening, ma'am. Chaitanya ma'am, good evening.
Good
Good
evening.
evening, sis. Okay, your voice very low voice, ma'am. Please
It's
check it. What, ma'am?
it's
It's
audible now?
audible now? Now it's audible, ma'am.
Okay.
Okay. Yeah. Ah. Good evening, sister. Good evening, ma'am. Good evening. Good evening, ma'am. Okay, Jayashree, let's start.
Okay, sister. Good evening, everyone. I welcome you all for the day 6 of the 7 days online National Faculty Development Program on emerging trends in intellectual property rights, organized by Vimla College Autonomous Thrissur in collaboration with the Inter-University Center for IPR Studies, Cochin University of Science and Technology. RVS College of Arts and Science, Coimbatore, and PSGR Krishnamal College for Women, Coimbatore. Let us begin today's session by invoking the blessings of Almighty with a silent prayer. Now, I invite Dr. S. Shamina, Associate Professor and Head, Department of Biochemistry, RVS College of Arts and Science, Sulur, Coimbatore, to introduce the resource person. Over to you, ma'am.
Yes, ma'am. Thank you. Good evening, ladies and gentlemen. On behalf of the organizing team, I take immense pleasure in introducing our chief guest of the day of 7-day FDP on emerging trends in intellectual property rights. Our guest of 6th day, Dr. Chaitanya Ma'am, EP, is an assistant professor in political science at SN College, Natica. Dr. Chaitanya Ma'am received her PhD degree in the year 2023 in political science from Inter-University Center for IPR Studies, Cochin University of Science and Technology, Kerala, under the guidance of Professor Bashi and Dr. Kavita Chalakal. Her PhD was in the role of state in the production of traditional knowledge in India. She has completed her MA in Politics and International Relations from 2007 at Mahatma Gandhi University, Kottayam, and her MPhil in Politics and International Relations in 2009 at Pondicherry Central University. She also received her bachelor degree in BA from Calicut University in 2005. She had received an Indian Biodiversity Congress Award for the best paper presentation and also acted as resource person in national seminar in the area of IPR and biodiversity. She has presented many papers in national and international conferences and has published many different journals in both in national and in international journals. Her main subject was about IPR and biodiversity. So such a famous personality with us, we welcome you, ma'am.
Chaitanya ma'am. Ma'am, please unmute ma'am.
So, is it audible to you?
Yes, ma'am. Okay.
Thank you. Good evening, one and all, and thank you for the welcome, warm and nice welcome. And first of all, I would like to thank Dr. Sister Beena, Principal of Vimala College, then Dr. Shivakumar, Principal of RVS College. Then I would like to thank Dr. Rajendran Sir, Associate Professor, Department of Biotechnology, PSC College of Arts and Science, and in the University Center for IPR Studies. And also, I would like to thank Dr. Sylvie Matthew, the coordinator of the seminar. I welcome all to my presentation. Shall I share my presentation?
Yes, ma'am.
Can you see?
Yes.
Okay, thank you. Okay, thank you. Shall I start?
Okay, ma'am, sure.
Okay. Today's topic is on intellectual property rights and biodiversity. So I start as we already discussed what is IPR and its relations with copyright and other type of IPR forms. So I just wanted to say that IPR is a legal rights granted to individuals for their creativity of their mind in the form of artistic works, symbols, names, images used in commerce or other forms. So it gives an exclusive right to the owners for the control and use of that creation for a specific period of time. As you have already understand that in patent it is given 24 years of rights. Even in copyright it gives 60 years of rights for the author. So likewise, IPR provides a creative mind. It's give a payoff to the person, those who are inventing something for their innovations. That the creativity of mind that given a recognition in the form of a monetary form, either in a monetary form or in a non-monetary forms. In there are several type of IPRs we have already come across, like patent, copyrights, and trademark, trade secret, and industrial designs. So these type of rights help to protect innovations and creations from unauthorized use, reproduction, or distribution. These are the main components or characteristics of IPR. When IPR I mean connection with, what is the connection of IPR with the biodiversity is interesting one. This is interesting because of the economic utilization behind it. What economic utilization with the biodiversity is the resources. What kind of resources biodiversity is given to us is in the form of plants, genetic resources, and the related knowledge. That knowledge we are using for innovations. They mainly the users of such knowledge are the pharmaceutical companies and cosmetic industries are using such knowledge for their innovations from the plants or genetic resources that are associated with them. So while looking at the biodiversity, we can see that biodiversity is a living organisms or life that is attached with a biodiversity that can be seen in several components like plants, animals, microorganisms, and the ecosystem in which they we live. So the biodiversity is essential for ecosystem sustainability and resilience and sustainability of the humankind. So it provides a wide range of ecosystem service to the humanity, such as clean air, water, soil fertility, and climate regulations. So what we call, generally we call biodiversity is this. And what is the relation between the IPR is interesting one. Next I am going to discuss with that. Biodiversity is also linked to the cultural diversity and traditional knowledge attached to the indigenous and local communities who lived in this close harmony with their natural surroundings for generations. Actually, biodiversity, when we talk about the biodiversity, we can see biodiversity in a species level, in a genetic material level, in a community. Those who are conserving these resources also comes under the purview of biodiversity. The biodiversity, that means cultural diversity, is attached to it because the community, those who are conserving these resources from time immemorial. Right? Are you hearing from me? Hello?
Yes, ma'am. Yes.
So the traditional knowledge is often includes the practice for sustainable resource management and utilization. So the biodiversity, when we use the term biodiversity, first of all, in the context of IPR, first of all, what comes in mind that the term is associated with the traditional knowledge. The knowledge that associated with the community, those who are holding it, and the knowledge associated with the biological resources and genetic resources that comes under the biodiversity, and that naturally leads to the IPR innovations. So the biodiversity, why the biodiversity is important in the context of India, because India is one of the mega biodiverse country, like Brazil, one among them. They are rich in resources, as India is rich in natural resources, and 34 globally identified. India is one among them. in the form of Himalaya, Indo-Burma, Western Ghats, Sri Lanka, and Sundarland. These are the regions we can see the rich abundance of biodiversity, and India is one among them. And we know that the traditional knowledge associated with biological diversity, India also a rich treasure of that knowledge also. So far, over 91,200 species of animals and 45,500 species of plants have been documented in 10 biographic regions of the country, and India one among them, according to the conventions of biological diversity. This shows that India is rich in biological materials and resources. So that's why India is a market for the international pharmaceutical companies. They are mainly approaching the Indian government for approval of such kind of materials. Next, I'm going to discuss what the connection with IPR and biodiversity. These are the generally we say the biodiversity is these things comes under biodiversity. When what connection with IPR is the innovations and creations are derived from the biological resources or traditional knowledge associated with biodiversity rich areas. Biodiversity rich areas, there are so many biodiversity rich areas are in India, like Orissa, Assam, Kerala is one among them, and so much of particularly the pharmaceutical companies and cosmetic companies are approaching for these resources, because these are the multinational or multi-billion that much of revenue is creating, not for the country but for the internationally also. They are creating revenues for the nations. So there are two kind of nations that are existing in our world, that is developed countries and developing countries. So what is the interesting thing is that the developing countries have they have the technology, we have the resources. So naturally, these countries, mainly particularly USA or UK, that kind of countries are approaching, even European countries, Germany or France, they are approaching for our natural resources, for their inventions and innovations. So these countries are rich in technology, but they are not rich in the case of resources like plants and genetic materials. So what we are doing is we are translating once. Hello.
Nothing, ma'am, I think.
It's audible.
Yes, ma'am. Yes, continue.
Okay.
Please continue.
So the rich countries in they're rich in technological countries, what they are doing is they are transferring these technologies to us in the form of biotechnology or genetics, you can see technologies like. But what we are doing is we are transferring these resources to these countries for their innovations, and in this regard they are giving some form of the benefit sharing to us. We will discuss that points later. And what are the challenges and concerns when IPR actually they are giving protection to innovations and creations of mind for a particular period of time for a particular person or individuals. That is more individualistic in nature. But when it comes to the biodiversity, we can see that the knowledge associated with these biodiversity or biodiversity related resources, we can see that is collective property of a community. So the problem is that in the traditional form of in the traditional way, we cannot protect these resources in the way the IPR given the protection to patent or copyright or trademark. For a patent, we can the protected for 20 years of period, whereas the collective property, it's a group property, it's a community property. They are owned by traditionally, we don't know, from generation. The traditional, we are called the method they are using, that's why we are calling it's a traditional way. The problem is that the traditional way we are using these resources, so the method they are using in a traditional way of nurturing and nourishing, So that may not be find when we are testing in a laboratory, may not be find some techniques we used for the modern scientific ways, that may not be passed by the traditional knowledge holders. So that's why that's one problem they are facing. So the IPR is for purely for individualistic and their innovations. When IPR comes to the biodiversity, the first concern is biopiracy. Biopiracy means unauthorized use or misappropriation of existing knowledge without acknowledging the local communities or even the countries. So the best example is neem and turmeric patent. Those patents have been granted in United States, and already they have granted in 1992, that period. And unfortunately, we don't know that they have granted. Later, we came to know that they have granted patent on neem and turmeric. So the CSIR has taken the initiative to revoke those patents. Later, we revoked those patents because the knowledge associated with neem and turmeric is we know, even small kids also know that what the usage of neem and turmeric, even in the case of India, because we are using these things in herbal properties like neem in Ayurvedic medicines, and turmeric it's a household name in our in our household course. So turmeric and neem patents, both these patents were taken by US. So later it were revoked. That is the problem associated with when IPR related to biodiversity. Next, another challenges is with the conflict with the traditional practices. They are collectively owning, and so the IPR gives emphasis to the individual ownership. So they create conflict between existing communal practice and the IPR framework. So another problem arising is when we are accessing these resources for commercial utilization or research or in the intellectual property innovations, it is the responsibility that those who are using these resources, at least they have to given a share or profit arising out of this commercial utilization. That is the primarily objective of this access and benefit sharing mechanism. Actually, this is in a practice, even in India and in other parts of the world also, this is not materialized as we expected. Because the companies, they are showing they have not shown that much interest in sharing profits to the communities. These access and benefit sharing concerns we will discuss later. So when looking at the protection of traditional knowledge of these communities, are even we have 20 years of 25 years we have concluded the Biological Diversity Act in India. Still, even in India and outside the world, still the problem of these communities, those who are holding this knowledge, is still is a complicated issue. They have not find out any better solution how these issues will be resolved. So the TK, they providing basis not only for not only for their survival, they are providing their knowledge, the community knowledge, for the betterment of the world itself. So what happened is for a certain period of time, the resources we have exchanged between the nations, because we are rich in resources. Some countries are lacking these resources, so we exchange these resources. We have no problem of that. So with the advent of biotechnology in 1930s, when US started the patenting of some varieties, then this kind of they started patenting of these varieties, but they are not acknowledging the communities, those who are protecting these resources. Then the third world countries started an agitation or a call for protection of these resources, because one side they are getting protection, on the other side the people, those who are conserving these resources, are not getting any profit or any protection from IPR resources. So what was the perception of the North was, all resources are common to all. That means common heritage of mankind. It can be used at anybody at anywhere of the world, and it has no restrictions upon. And even somebody wants to somebody wants to enter into this knowledge, nobody, no authority is there to restrict them. So on the such cases, countries like India and Brazil have stood up against that, and they have called for an initiative internationally to protect such resources. So the advancement of technology, especially the biotechnology, has demonstrated the significance and usefulness of TK for the development of products for commercial importance. So naturally that the industries get protection, but the communities, those who are holding the countries, those who are holding the resources, not getting the protection. So this also challenges the existence of communities, not naturally that affecting their livelihood. So naturally there was call for a protection internationally for the for traditional knowledge protection. So what was the result was, each and every country, the resources and the depository was not uniform. So some countries have more rich in resources, some countries may not have that much, but they have. So the standard setting was left to the state can decide what kind of way and method you can protect your resources, because you know that sometimes state may be India may be the owner of the resources. Within India, maybe community may be the owner of the resources. Sometimes we may be owner of the resources. So we don't know who may be the original owners and holders of such resources. So internationally, they have taken the stand that it is up to the national governments. They can decide whether to protect or not such resources. So the result of that international discussion was the form of the Convention of Biodiversity. We call short, in a short, we call as a CBD, the Convention of Biodiversity of 1992. That was a byproduct of international agreement. And one another agreement we call Nagoya Protocol that came into 2010. When looking at the Convention of Biodiversity, it has three main objectives, such as the conservation of biodiversity, that is much more important in this scenario. So the sustainable use of these components of biological diversity, not threaten to the communities, those who are reserving it. And if you are using such resources, the countries should give at least a fair and equitable benefit arising out of the commercial utilization must be shared with the, if you are able to find out the communities, no problem. If you are country, you should able to share some of the profit arising out of the commercial utilization. So keeping these objectives in mind, India also be party to the Convention of Biodiversity. So India cannot be moved away with some international agreements, as we know that it's also a part of one side politics. We can see that it's a part of a neoliberal program that nobody can move away with any international agreements. It is some way, so for a certain extent, it is a legally binding agreement. So it's a responsibility of a country to amend it. Enacted it. So accordingly, India has enacted Biological Diversity Act of 2002 in accordance to the Convention of Biological Diversity. So we have the Biological Diversity of 2002. And recently, what we did is we have amended certain provisions of biodiversity to accommodate some interest, like not the interest of the communities, those who are conserving it, but to protect the interest of pharmaceutical industry, scientific communities, and biotech companies, like the Ayush companies and the Patanjali companies like that. So we recently, the Parliament has amended the existing provisions has amended in accordance to the not in accordance with the international convention. International convention has already said that conservation, sustainable use, and fair, equitable benefit sharing is the main objectives of these agreements. But for a certain extent, we have included these provisions, but in provisions we have, but in the realization of these provisions, we have amended some of these provisions to accommodate some interests. So the another international agreement in accordance with the Convention of Biodiversity is Nagoya Protocol. Nagoya Protocol that was actually came into effect in 2010, and India also party to the negotiation. One interesting thing is that there are three objectives that we have identified for the protection of biodiversity. That is conservation and sustainable use and fair and equitable benefit sharing. What we can see that was enacted, the Convention of Biodiversity was enacted in 1992. After this much of years we have come across, later we came to know that the some of the principles are not implemented as properly by many countries, and the nature of this document is non-legal binding. So we have no obligation to to came into effect these provisions because it's non-legally binding. So the main objective of Nagoya Protocol is mainly the implementation of benefit sharing mechanism, which is not finding as we expected. In many some countries they are giving some kind of monetary benefits. Some countries may not be giving monetary benefits to the communities. So even the communities within the countries, they are not giving any kind of remuneration to the community. That's why we have concluded a protocol called Nagoya Protocol. And then we come to the Indian Biodiversity Act of 2002. We can clearly see that some of the objectives, main objectives of CBD are also present in our act also. The conservation, sustainable use of it, and fair and equitable benefit sharing out of the same. And what are the activities we regulated by the Biodiversity Act is that when we are accessing these resources for research, biosurvey, bioutilization, or commercial utilization, or obtaining IP rights and transfer of research and transfer of access biological resources or associated knowledges. The main object of this act is to regulate some activities which leading to the such as the research, commercial utilization, or biosurvey or bioutilization, and transfer of IP rights, collaborative research. Such kind of activities are regulated in accordance with the Biodiversity Act of 2002. By looking at the structure of the Act, that was introduced in 2002 in a decentralized way that envisages to give some kind of say to the communities, those who are conserving these resources. So that's why we have given a decentralized structures like National Biodiversity Authority in the top. They will regulate and they will thoroughly check whether the resources are accessing illegally by any third parties. So then constituted a state biodiversity board. Even Kerala, we have a state biodiversity board located at Trivandrum. Almost 28 or 29, I think 29 state biodiversity boards are operating now, and 29 biodiversity management committee, that is the lowest rung in this decentralized way, that is biodiversity management committee. I think it's 29 biodiversity management committees are constituted in each and every part of our country. And while looking at the National Biodiversity Authority structure, it is under the Ministry of Environment and Forest Ministry, and it is a statutory and autonomous body headquartered in Chennai. And second thing is that the State Biodiversity Board, as I mentioned, is created in 29 states along with the BMC for each local body. While looking at the structure, we can see that a person would be there for taking the decision, and he was followed by 6 ex officio members from various departments like agriculture, tribal development, actually the central government, what are the central government's department was there, also party to them, also the members of 6 official members and 4 representatives from the state biodiversity board and 1 member secretary. That is a structure of National Biodiversity Authority. Well, what are the functions of Biodiversity Authority have? These are some of the functions. Just monitoring and prevention of action prohibited under the Act. Just monitor whether the resource, somebody is accessing the resources without the knowledge of National Biodiversity Authority, and provide advice to the government how to conserve the biodiversity in India, and prepare and submit report to government, and intergovernmental meetings would be conducted in different parts of the world. So that time it is as per the Convention of Biodiversity, it is mandatory to we have to submit the report to the Convention of Biodiversity as a report on how much status we have achieved and what are the how much sustainable development we have achieved, how much conservation we have achieved, and all those reports we have to submit before the Convention of Biodiversity that may be convened in different parts, like Geneva, somewhere in Geneva or somewhere in Brazil they have convened. Even in India, I think 12th Convention of Biodiversity was convened in India, in Hyderabad. And another point is to make concrete step to prevent grant of intellectual property rights regarding locally used biological resources allied with traditional knowledge. And that's the main one of the function of these the biodiversity, National Biodiversity Authority, is to prevent the grant of intellectual property rights without the knowledge. Another powers and functions of MBA is to, while a person from, actually these provisions in the Section 3 of Biodiversity Act, which clearly says that who can approach Biodiversity Authority for accessing the resources or obtaining IPR. So these are the persons covered under this Act. The non-citizens or non-resident citizens, or body or corporate or association, like organizations not registered in India. Even if registered in India, they have non-Indian shareholdings or management. These are the persons who are actually they're envisaging as not Indian citizens. They are clearly, as per the new amendment, they are clearly saying that foreign controlled companies will require permission before accessing the resources. We have to require to take permission from Indian Biodiversity Authority for obtaining resources, or also IPR. The IPR in the sense patent, mainly the patent. So these peoples are covers under the Section 3. When we are accessing these resources, prior approval of the National Biodiversity is necessary when we are from a foreign company or a foreign person. And next, even in the case of an individual, even if a case of an individual from India approaching these for a National Biodiversity Authority for accessing the resources or obtaining these resources, earlier there was a provision that under Section 4, Indian citizens also must inform the National Biodiversity Authority for obtaining IPR. If we are accessing this tulasi or neem from our place, it's just go and intimate. Or if you are accessing any resources, you just go and intimate the concerned SSB that we are accessing the resources. Just intimation, no approval. Just intimating I'm taking these resources. That's it. But if we are going for a patent or transfer of research results, such kind of things are happening, you should go and take approval from the National Biodiversity Authority. That was the practice was going on before the amendment. After the amendment, what was happened that if you are a Indian individual, you just go and register with NBA. You need not take prior approval at the time of registration. If you are getting the patent granted, at the time you should go and ask the permission from the concerned NBA people. And any application under the section 6 also, that is clearly with the IPR, any application of transfer of research result or collaborative project also, you should earlier, what was the condition? You should go and take the prior informed consent from NBA for accessing these resources or obtaining the resources or obtaining the IPR. You should go and inform them. But after this amendment, what happened is you just register with MBA. What they're saying that it taking time while accessing the resources and go to the authority for the consent, and after getting the approval from them, it may take time. So in order to reduce that time period, the better way found by the NBA is to register. After granting the patent, obviously they will grant the approval. That was the practice going on now. And another function of NBA is under section 21. While accessing the resources, somebody is approaching us, National Biodiversity Authority. It is the duty of the authority to find out whether they have satisfied the conditions, they have acquired the prior informed consent from the authority on mutually agreed terms. Actually, the prior informed consent, the act was envisaging the prior informed consent not taken from the National Biodiversity Authority. It must be taken from the local and indigenous communities. That was the practice actually envisaged by the act, as written in the act. But in practice, what we are doing that with the scientists or persons, those who are approaching these authority, have no time to spend. At least it may be taken, sometime it may be taken 30 days, sometime it may be taken more than that. So they don't have that much of time to go for it. So what they did is they just go and approach the National Biodiversity Authority. Authority will give. There are two persons in this agreement. One is the persons, those who are giving the resources, and those person who are approaching for the resources. So it is the duty of NBA to be to consult with these people on mutually agreed terms. Mutually agreed terms in the sense that you should in a proper form is there, and that form they must have to written down that this much of benefit we will give out of our commercial utilization. In India, we most of the times what practice is going on, we have written down in the these following words, that most of the times we are not going through what kind of innovations actually happened when our resources is accessed by somebody in outside India. Some cases in another countries, they have going through these processes, and they filed 5% or 10% from the companies before the commercial utilization of these resources. But in India, we are taking the benefit sharing out of these resources after the commercial utilization of these resources. That is one problem we are facing now. So most of the cases we are giving, there are two ways of benefit sharing. One is monetary benefit sharing, and actually 5% or 6%, it's up to the companies, and NBS is fixed by the 5%, and 5% is shared between the communities and NBA. And most of the cases we are taking the non-monetary benefit in the form of biotechnology transfer, technology transfer, like that. So the rest, what we can see that the Biodiversity Authority, they are using this money for the betterment of the local community, such as the Association of Indian Scientists, benefit claimers, local people with research and development in biological resources, biosurvey and bioutilization, setting up of venture capital fund for aiding the causes of benefit claimers. Benefit claimers, which means that the community, those who are holding these resources, are considered as a benefit claimers. Payment of monetary compensation and other monetary benefit to benefit claimers, as national, it's up to the National Biodiversity Authority. They will decide either in a monetary form or non-monetary form of benefit sharing. Some benefit sharing is happened if money it's given by the accessors or utilizers of the resources. That money would be kept in National Biodiversity Fund. Later, that may be, most of the cases, these resources may be used for the buildings and create awareness, those kind of programs, not to the development of community. That is actually we are seen in the case of, you may be heard about Kani tribes. Kani tribes, one of the communities, those who are living in Kerala, and they have find out a drug called with the association of Ayurveda Shala, Jeevani. One drug called Jeevani was found out, and between the license between the community and Ayurveda Shala, they have shared some amount of money to the community for replanting the plant for the Jeevani drugs in future. But what happened is that they have the biodiversity authority, they have used this money for the awareness programs and building some infrastructure things like that, for not for the betterment of the community. That was happened in Kani tribes. Jeevani drug is the only example we can showcase before the international community that we have done at least a benefit sharing mechanism for the betterment of the community for a certain extent. After that, we have no examples to showcase to that we have done this much of benefit sharing and this much we have we have derived from the commercial utilization. And what are the roles NBA have? Even most of the cases, what we can see that so many patents have been granted. But what happened, NBA is there. The NBA main function is to oppose function is to look whether any biological resources are accessed illegally. If accessed illegally, it is the duty of the authority to find out and give some penalties or give some time to the person to find out, or give some evidence from where they have accessed this knowledge. If they are successful in producing the documents, obviously NBA will grant the patent. Most of the cases, what happened is, without the knowledge of NBA, these resources have accessed. In India, most of the resources have access either through airport or seaport. We have no mechanism. Now we have a mechanism of clear house mechanism, like we have checkpoints. The NBA is the authority, and they have thoroughly checking after these incidents have happened. Most of the case, Monsanto's European patent for Indian the Indian virus-resistant melon case. That is one case. The interesting thing is that without the knowledge of NBA that has gone from our country, later the environment group like Navadanya that is run by I don't remember the name, sorry. I don't remember that lady name. Navadanya and the European NGOs, actually they fought Vandana Shiva. Vandana Shiva's NGO, Vandana Shiva's organization is Navadanya. She and her European counterpart NGOs these people were go behind it, and at last revoked the patent. Another case is happened in BT Brinjal case, that is Indian term for eggplant. BT Brinjal, that case is still going on, even pending before High Court of Karnataka. 16 varieties have been accessed by these Moyoco Monsanto's subsidiary company is Moyoco, and they have accessed these resources. This was happened without the knowledge of National Biodiversity Authority. That's a duty of authority to to regulate, check whether some resources have access or not, but without the knowledge of NBA, it has gone from our country. Later, environmental support group came to know, and they have challenged it before the court. Still, this case is pending. The case is still going on, and it's not ended. It started in way back 2010. And another case was filed against in 2019 was Suven Pharma for a wrongful disclosure of patent process. The wrongful disclosure means we are accessing the resources from somewhere, and in patent, I will discuss that point later. In patent, before granting the patent in the case of traditional knowledge or associated knowledge, it is the duty of patentee to disclose from where these resources are accessed. If we are failing to produce those evidences, there should be a provision to revoke such patent, and there would be a penalty for giving wrongful information regarding it. So the Suven Pharma, what they did is that they have already got patent in many countries such as United States, South Korea, Mexico. This is also happened without the approval of National Biodiversity Authority. If you are, especially in the National Biodiversity Authority, there's a clear provision that we are going for IPR or patent. You should go and take permission from National Biodiversity Authority. In this case, it's not happened. So it was not they weren't aware of that. Later, it was actually came into Indian Patent Office databases. We searched later in 2018. This patent number has granted, but they have given. What happened is that person is most of the cases the person, one person from India, another person from foreign country. These resources or research may be happened in other counterparts. So most of the cases, one Indian may be involved because they were well aware of that, what kind of knowledge we have and what kind of resources we can access from any parts of the country. So one Indian would be involved in such cases. Later, what happened is he took some, how he got patent is that he took some resources from China, some extract of oils and plants from India, and he mixed up with those things, and he got patent. Later, we came to know that he accessed these resources from India itself, and he has not approached the authority for granting of IPR. So later it came to know the what is the current status of the case is not available anywhere in the Indian Patent Office or NBR national report. Both these cases I have searched many times, but I don't get any data regarding how this case is going on, or it is posed for a wrongful disclosure of patent process or not. Then other authority for regulating this access and activity is given permission, that is State Biodiversity Authority. State Biodiversity Authority would be a chairperson and not more than 5 ex officio members to be appointed by state government to represent concerned department of state government, and not more than 5 members to appoint from among experts in matters relating to the conservation of biodiversity, sustainable use, and equitable benefit sharing of the resources. And while looking at the functions, is advise the state government subject to any guidelines issued by state government, central government, on matters relating to conservation, sustainable use, and fair and equitable benefit sharing, and regulate and granting of approvals, otherwise request for commercial utilization or IPR or by Indians. When foreigner is approaching, they directly go to the National Biodiversity Authority. When Indian is approaching for access and benefit sharing, they directly go and give intimation. If you are going for a commercial utilization or IPR or transfer of research result, you should go and take permission from the State Biodiversity Authority. State Biodiversity Authorities mainly look after things when connected to Indians. and perform such other functions may be necessary to carry out the provisions of this act or may be prescribed by the state government. Most of the functions they are going through is to constitute PBR, People Biodiversity Register. In our local bodies also, we can see the People Biodiversity Register. What all the resources have been have been in the locality. We will we will record in the People Biodiversity Register. The problem is that legal sanctity of such register is still in a problem. So the discussions are going on. That is another function of the SSP. Another function of biodiversity, the structure. In the structure, the last one is the Biodiversity Management Committee. In this committee, we can see a chairperson and 6 persons nominated by local body. The decentralized mechanism, the people, local body, the persons who have knowledge, that are the main, the protectors of this Biodiversity Management Committee. And this managed committee should be women, and not less than 1/3 women should be there, and not less than scheduled tribes and scheduled caste representations would be there. And while looking at the provisions of BMC, section 41(1), every local body should constitute a biodiversity management committee within the area for purpose of promoting conservation, sustainable use, and documentation of biological resources, including preservation of habitats, conservation of landrace, flock varieties, cultivators, and domestic stocks, and breeds of animal and microorganism, chronicling of knowledge relating to the biological diversity. The documentation is the main function. The People Biodiversity Register, that means documentation of knowledge of biological diversity. And the section 41(2), as I mentioned earlier, if NBA and SSB shall consult the Biodiversity Management Committee while taking any decision relating to the use of biological resources and knowledge associated with such resources occurring within the territorial jurisdiction of BMC. It is the duty, it is clearly mentioned in the Biodiversity Act that whether SSB or NBA, while taking those resources from the judicial discretion of BMC, you should go and consult with them and get approval, prior approved consent. That means we call PIC, that is prior informed consent. What we did is, internationally we use the word prior informed consent. When we can see in our act, shall consult the Biodiversity Management Committee, shall consult, not the prior informed consent, not the consent, consult. That is the terminological difference. We can see that is purely a dilution of international agreements when concerned to the communities. The BMC, another functions they have, they can levy the charges, the way of collection of fees from any person for accessing their resources for commercial purpose from the jurisdiction area, and prepare biological diversity registers also. So they have the power to levy the charges for accessing the resources. Unfortunately, these things have not been happened anywhere, because this kind of consultation may not be reached to the BMC. Most of the cases NBA will decide, and sometimes SSB. Most of the cases this is not happen because most of the resources are not accessing from the Biological Management Committee or local body area. Sometimes these resources they are accessing either from the local market or from eliciting bioprospecting. So they are taking these resources somewhere else and keep it in the bag, and they either go through the seaport or airport. So this kind of practice are going on. That is one major hurdle we are facing. That's why most of the resources most of the cases benefit sharing mechanism, it's not happening. If benefit sharing is actually derived from this commercial utilization, local body fund is constituted at every state government. This fund can be used either for the betterment of the society, for either for the or for the I already said, for the capacity building, or for the development of construction of buildings such as like that. Most of the cases, this is the practice going on. And one interesting thing is in the Biodiversity Act. The main function of this Biodiversity Act or international agreements is share the benefit arising out of the commercial utilization. In this case, we can actually see these kind of people are excluded from the benefit sharing provisions. Normally traded commodities under the section 40. Normally traded commodities means sometime maybe brinjal, tomato, like that is considered as a bioresources in our Biodiversity Act. That is normally we have given for trading purpose. So we exempt those things from the purview of approval. They may not be needed any kind of approval from NBA or SSB or BMC. They can normally trade these commodities for the commercial utilization or IPR, obtaining IPR. So what happened is most of these resources are going through these normally traded commodities. The cases I have mentioned is when pharma cases, this is the normally traded commodities, one of the resources he has accessed, and he have written in the document that he have accessed these biological resources in the normally traded commodity. One resource is accessed that is come under the normally traded commodities. So he has written that he has not obliged to share or getting any information or any approval from any authority. So this is the one way the resources are illegally going out. Earlier, when the Biodiversity Act was constituted, that time it was around 90. Now 401 items have been exempted from the normally traded commodities. And traditional healers such as Vaidyas, Hakims are exempted because they are the holders and owners of the knowledge. That's why they have excluded from the if they are using the resources for innovations or things like that. They have no there is no point to go and take approval from the National Biodiversity Authority, as in the case of foreigners or as in the case of Indians. They have no need not to take any approval from any of these authorities. That is actually the section 7 or actually the act has envisaged like that. In a collaborative research also, we have exempted from the purview of benefit sharing or taking permission from the authorities. But as I mentioned earlier, as per the new amendment, they have extended this provision to some other categories also, like codified traditional knowledge. The codified traditional knowledge is not defined in our act. Accordingly, they are saying that codified traditional knowledge are in the form of Ayurveda text, Unani, Siddha, Ayurveda text like form of codified, that is called as codified. Actually, internationally, there is a practice that the codified knowledge has not given any kind of recognition. So there is a international argument. Discussions are going on whether codified traditional knowledge would be exempted or it would be come under the purview of benefit sharing or not. So India has introduced codified traditional knowledge because we are rich in resources, also rich in the sense of Ayurveda texts, Unani, Siddha, and like that. So another section have exempted from the purview of Biodiversity Act is cultivated medicinal plants and products. There are already persons who are cultivating these. They have the exemption. They have not need to go and take permission from NBA or SSB or even from the management committee, or they don't give any benefit sharing to the communities. Ayush practitioners, Ayush in the sense Ayurveda, Siddha, Unani practitioners also exempted from the purview of that. Actually, this section was envisaged only for the traditional healers, and that means Vaidyans and Hakims, those who are practicing traditionally, exempted from the purview of that. Due to the recent policy of central government, ease of doing business. One policy they have introduced as ease of doing business means give as much as relaxations to the people, those who are doing business in these sectors, such as Ayurveda or cultivated medicine plants or codified traditional knowledge. They are not supposed to give any kind of rupees or any kind of benefit to the communities or even the government for accessing the resources. So this is one what you say the against the spirit of international agreement. And so what would be the implication will be we will dealing with in the future. So it will be a huge lap for the medicine and pharmaceutical companies like Patanjali or like that. They are going to getting more benefit out of this provision. Current status of benefit sharing. In total, till 2021, the after 21-22, that report has not been available in our National Biodiversity Authority website. They have given that 2,592 agreements they have already signed up during the period of 2021, and they have accrued received some amount of 8 crores as a benefit sharing component, which include upfront payment, commercial utilization, royalty, etc. But what is we can see that most of the cases we are accessing these resources from communities. Sometimes we may know the communities, those who are accessing the resources, so it is easy for a even if National Biodiversity Authority or State Biodiversity Authority to directly give these benefit to the communities. Most of the cases this is not happening because as I already told that these resources sometimes they are accessing from the illegal way. So 2 cases we can see the benefit sharing has materialized. One is Red Sanders Wood, the PepsiCo holding. Another is the seaweed case. In both cases, they have not find out the communities, those who are concerned it. In the seaweed cases, some initiative has been taken. They are saying that the seaweed has been collected PepsiCo from the Tamil Nadu area, and Red Sanders Wood, they have not find out yet who is the actual owners and holders of such knowledge. So in these both cases, this money is still in the kitty of National Biodiversity Authority. And if you are breaching, what offences and penalties if you are breaching these provisions, what would be the outcome and what would be the penalties and offences? Offences we under the act were earlier were punishable with imprisonment up to 5 years, and also we have to given the money 5 in imprisonment of 5 years, or in the case of money, or sometimes both may be given to the offenders. And this is non-bailable and coercible provision. And after the, as I mentioned, as a ease of doing business, as a part of ease of doing business, amendment has decriminalized this provision and made all offences punishable with a penalty between 1 lakh to 500 lakhs. They have concluded into a small kind of punishment and penalty, because most of these accessors are from foreign or Indian entities. So they are commercially they are attached with these authorities. So as a part of ease of doing business, there's relaxing this provision also, and this is also going to be a tough decision in tough thing in future. And what are the challenges in the implementation of biodiversity we are facing today? Actually, we have Biodiversity Act, we have Patent Act, we have Plant Variety Act. The 3 acts are functioning even today, but none of this act has given a particular protection to the biodiversity associated knowledge or by the people, those who are conserving it. The problem is that the owners of TK, we cannot find out who owns these resources. Sometimes state saying that international conventions, while looking at the international conventions, state are representing for us. So the state are saying that we are the owners or the holders. While come to India, actually the holders and owners are the local communities. But there is some terminological or political problems are there to to recognize the communities, those who are holding the resources. Another problem we are facing is the diverse nature of these resources. Sometimes it may belong to individual, and sometimes it belongs to an individual or group or state. So we don't know who are the actual owners and holders of this such knowledge. And the same resources we can see in Western Ghats, in Himalayas. So at that point, we don't know who are the actual owners and holders. The same resources can be seen in some other states. The same resources may be seen in the case of basmati, that is also available in India, or also available in Pakistan. So such kind of the problems are arising. What to do in such situation? It's clearly defined internationally that transboundary cooperation has been established, has been one way of looking it. But in Indian provision, we have no transboundary cooperation. Just we ignore that part. Most of the cases, we say that owners and holders are indigenous and local communities. We say that we don't have such kind of people. State is the owner and holder of such resources. And another problem is traceability and benefit sharing concern. As I said, same resources can be seen in Himalayas or Western Ghats. Same resources can be seen in Kerala, Karnataka, Tamil Nadu. The same resources can be seen in Himalayan parts, Himalayan regions also, in Himachal Pradesh or Ladakh or somewhere else. So such kind of situation, like in turmeric, ginger, medicinal plants, these are medicinal plants can be seen each and every nook and corner of our country. And some particular kind of medicinal properties that have been used by communities and some groups. So it is sometimes we may find out the some communities or group holding. Sometimes we may not be in a position to find out the communities and holders of such knowledge, because the same resources are span across the nation. So the uneven distribution of resources is also one problem. Another, I already mentioned earlier, the normally traded commodities. Normally exemption has given to the such commodities, so we have no provisions to revoke or granting patents such on normally traded commodities. Another problem is that resources taken from wild and original owners, wild medicinal plants and properties that we have taken, we don't know original holders who are. Sometimes agriculture university using these varieties, wild varieties, and they have introduced another variety from these derived varieties from the original varieties. So the parallel line of community holders may be used, so the same community then use the hybrid variety. So it is actually a problem that nowadays even the local communities are also using the hybrid varieties have been produced by these agriculture communities. So it's also a problem to find out who are the owners of such knowledge. Some of the act for certain extent have been given some recognition to biodiversity associated knowledge. As we know that the Patent Act up to 1970, we have no intention to protect the traditional knowledge, associated traditional knowledge, because we have no experience of biopiracy. After Neem and turmeric cases has come up, so then after that we started thinking of how to combat this biopiracy. As a result of that, this, we have amended the Patent Act 2002 and 2005. We have amended and we have added certain provision for a certain extent to protect TK from the misappropriation. Section 3P is an important one, an invention in which effort is TK and aggregation and duplication of the same knowledge. As we know that the medicinal plants of tulasi can be used for this cough or cold or whatever. That knowledge cannot be duplicate or aggregate for a patent. What did is normally pharmaceutical companies they are accessing the resources. They know what medicinal properties these plants have. They will use another techniques or methods and reproduce it in a different way, and they are getting patent out of it. That's happening. Even these professionals are there, but they are doing it in another way. Another clause has been added to section 10.4. Disclosure of source or geographical origin of material you have used in the invention based on the biological material. If you have used resources like tulasi neem, you should give the disclosure agreement. You clearly mention from where, from what time, from which date you have accessed these resources. If you have failed to do this, the result is revocation of the patent. Another section have attached to this is the patent opposition, 25J and K. During the instance of unauthorized use of, unauthorized use means in a patent we have to say that at least knowledge of community should be acquired from the use of this such knowledge. Unauthorized use can be a reason for the revocation of patent. And 64 section 64P and Q has been used to give more effectiveness of this above session, that patent application can be revoked. Information is not given or wrongly mentioned. Wrongful disclosure of, as I already mentioned in the case of Suven Pharma case, wrongful disclosure. But there is a provision in the Patent Act too. If you are giving the wrongful information, there is a chance to revoke your patent under the section 64. Another act which give a certain extent protection for the biodiversity is the Protection of Plant Variety in Farmers' Right Act 2001. You may be you are going to hear a lot about these provisions in later classes. So I'm confined to this only to IPR and traditional knowledge. In this session, in this act, farmer is considered as a breeder. A farmer can be group of person, and community of farmer can be considered as a breeder. And for a breeder, he will reward, but there is no special provision to attach this addition. The farmer can be treated as a breeder. He can be breed as farmer is doing with a variety. Likewise, he can be go for a as a the what do you say? He can also produce a variety. He can be called as a breeder. A breeder should be in the form of a group of farmer or community of farmer. Is the specialty of the traditional variety using farmers. That means they are the nurture and nourishing these resources time memorial in a wild and relative land race, flock varieties. Co-equal rights are given, no differential treatment for the variety. Co-equal rights they are given in the sense farmer can be treated as a breeder, breeder can be treated as a farmer. But the problem is that when a farmer, a breeder, he has to, according to this act, a farmer has to show some testing method like DUS, distinctiveness, uniformity, and stability for their variety in a scientific manner in a laboratory. While the same provision we are applying in the case of wildlife or community farmer using technology, it may not be replicate these characteristics because they are not a time-tested varieties. They are we are using these resources time memorially. Traditionally, we are nurturing and nourishing. They may not be show the characteristics as the scientific varieties are showing in the laboratory test. So that's why most of the cases farmers are failing in the DUS test. But actually, the people those who are given this provision, actually, they clearly knows that DUS test. The most of the cases farmers varieties are falling under the DUS provision, but they have included. Farmers are not getting any immunity from the registration formality. They have to pay the statutory. While looking at the farmers variety, there's clearly mentioned that they have not to give any fee like that. But in practice, they have to give fee. Earlier it was 2,000. Now after the agitations and movements from the farmers of India, later they reduced it to rupees 10. And other statutory fees for registering a variety, for getting the registration again, he has to pay annual fee, and hiring a person for PVF filing application. The case is that most of these authorities are in Delhi, and they have they have what you say, published these informations in a plant variety journal that may be either in English or in Hindi. Most of the cases, these poor farmers, they are illiterate. They have not knowledge of the legal implications and legal readings. So most of the cases, they have to hire the person like advocates or scientists. So they have to give the fee around for registering a variety. Around they have to spend around 70,000 to 1 lakh. Most of the cases, nowadays more of the farmers are getting their variety registered, and what of the outcome is getting from this registration is still uh, not known to the communities also. And benefit sharing is also a provision in PVR Act. Benefit sharing, as I mentioned earlier, if knows that the farmers varieties has been used by the companies, they should give some benefit share to the community. It is the duty of the community to file for a benefit sharing, not the plant variety authority has come and given money to the community. Most of the cases, it is the duty of the farmer to check whether his resources has been accessed or not. Compensation is the same case. It is the duty of the farmer to go and check whether some varieties have been accessed or some varieties have been failed to give some expected outcome. It is the duty of the farmer to go and file a case against them. And even the infringement also, it is the duty of the farmer. So my conclusion is that in the case of India, we considered biodiversity as a product for commercial utilization. That's why we amended our existing provisions accordingly, the interest of corporate or scientific interest, not in the interest of local communities or indigenous communities, as enshrined in the principles of Nagoya Protocol or Convention of Biodiversity. The vision of transforming India into a globally competitive economy has shaped a particular techno-scientific and regulatory regime that relevant to the plant and genetic resources associated with TK in Plant Variety Act or Biodiversity Act or Patent Act. All those acts we have come across, and we getting to know that we have introduced this kind of legislation not by the intention of bureaucrats. Intention of bureaucrats was something else. After the persuasion of farmers or local communities or NGOs, at least some provisions has been introduced as due to this outside pressures and challenges. That's why some up to 1970 we have a provision for protection of TK because of NGOs. Actually the neem and that case, turmeric case. Because of that, some provisions we have added. The Plant Variety Act 2001, we have the provision only for breeders. They have no provision for farmers up to 1991, 1999. Up to 1999, our provisions was only for breeders. After the persuasion from NGOs and from the farmers' side, they have introduced a provision for the farmers' variety. And Biodiversity Act 2, the same kind of politics was there to not include the communities who are holding the resources. So internationally, while looking at the several provisions for the protection of the communities or the people, India does not take up to those measures as certain provisions was there, did not use the flexibilities provided by CBD and Nagoya, devising a standalone or sui generis mechanism for traditional knowledge. Another problem we are finding is that there is no internationally agreed norms or binding legal instrument that pressurizing us to devise a mechanism for the protection of traditional knowledge in India. So that's why we have no pressure. That's why we are making the legislation up to our requirements and our current scenario as part of ease of doing business. As a pay, the lots of as per the new amendment, there is lot of relaxations given to the patentees, relaxation given to the Ayurveda practitioners, relaxation given to the cultivation of medicinal plants, relaxation for normally traded commodities. So it's given the impressions that the biodiversity nowadays is considered as a property for the commercial utilization, and the motto nowadays the government has itself promoting such thinking among. They are in the 2000 national IPR policy of 2016. They have clearly mentioned as much as patent to be given in a traditional knowledge related areas. That is one motto, that is the prime motive behind such a initiative. So it is the time to it is the need of our to check a certain extent of the resources for commercial utilization. Otherwise the future generation will suffer. That's it. Thank you.
Thank you, ma'am, for that insightful lecture. Now the platform is open for discussion. If you have any queries, you can unmute and ask. Audience, you can also type in the chat box. Is there any question?
Ma'am, my doubt is that you were talking about the sharing, sharing of advantage. Ma'am,
One minute, please. It's not audible to me because I think I have some problems in my system. Please continue.
Hello, ma'am. This sharing, access and sharing, ma'am, don't you think since we are dealing with an unorganized community, it would be very disadvantageous for them because they do not have the, means like you said that the act itself, Amendment Act, it gave greater advantage even to the various powers like various brands like Patanjali and all. So don't you think that these communities with this traditional knowledge do not have the capacity to demand what because they don't know the monetary value of their tribal people, and these indigenous communities, they do not know the monetary value of their knowledge. So do you think there are more chances of exploitation, and what has the act actually done in order to prevent this kind of exploitation of this particular community? That is, who would be the channel of making this demand for them? Because they won't be having, because usually in case of contract act, there is always a kind of demand. There's a, what you say, the demanding power between the two persons who are sharing or in when agreements are made. And with regard to the indigenous community, they do not have that full capacity to make their kind of demands. So how do you think that they would they be in a beneficial position after the Biodiversity Act has come?
Which shows that the provisions are there, but implementing parties are taking it in another way. There is clearly mentioned in the section 21 that before accessing the resources, you should go and consult with the Biodiversity Management Committee. What practicing is that nobody is going these communities and even getting any approval. Actually, a National Biodiversity Authority is taking the approval and given the permission for accessing the resources. If the government has a certain kind of regard to these communities, at least they could not do any amendments to the particular section. They have amended those provisions particularly for the benefit of the certain community, the communities in the sense of scientific community, biotechnology industries. That is actually the international agreements, they have clearly written and they have clearly said to countries like India that You have indigenous and local communities are the holders of such knowledge. Because of political connotation attached with that particular term has provoked the government to not implement such a term, because certain rights, in the sense, they have to decide whether to give permission or not. They have the right to restrict the people, those who are accessing these resources. Certain rights attached with them. That rights is given certain kind of threatening feeling to the government. So at least they are taking the responsibility that the state is owner of the resources. That is actually happened in India. That is what is my experience when I am doing the research. I have approached several authorities, and they have given the harsh criticism and harsh response with regard to this implementation of this act.
Ma'am, even not only the Biodiversity Act, as far as the tribal community is concerned,
One
even
minute,
the
one
Forest
minute.
Act.
I think I have problem in my this. 1 minute. I can't hear it. Tell me.
Ma'am, not only the Biodiversity Act, even the Forest Act has been very,
Yeah.
what do you say, negatively impacted the tribal people. So most of our knowledge is with them. Besides that, ma'am, the Biodiversity Act has insisted for maintenance of a biodiversity registry by the law,
Yeah.
and it has been that duty has been given to the local self-governments in the country. But as far as my knowledge is concerned, the local self-governments in the country, as far as Kerala is concerned, and I believe all in others also, they are not giving much trust to it, because very much importance is there on the biodiversity registry, because we had to fight for, I believe, more than 20 years before the turmeric patency in order to go against the turmeric patency, which was going to be given by the US. Then last we were able to prove that in our old scriptures. There was regarding to the therapeutical use of turmeric.
Efficacy.
So, if this is not properly implemented, ma'am, what would be the purpose of this particular act in effect? Would lead to more exploitation or more venues for exploitation of these indigenous communities.
That is what
Provisions of the act itself, the biological diversity register. You may be heard about TKDL. One provision, one registry is there. TKDL, the use of
Yes.
protection mechanism, that at least one can, if some patenting of traditional knowledge has happened in somewhere, through TKDL we can revoke. That is available in 15 languages around the world. So the problem is that while we are putting these knowledge associated things in these TKDL or people biodiversity register, there is a problem of misappropriation of resources again. We don't know who are going to access these resources, how they are going to use these resources. So there is no legal protection attached to the TKDL or people biodiversity register when we are registering this knowledge, or the characteristics of this knowledge, or what are the outcome or result if we are using this knowledge. Some of these knowledges we are uploading these registries, there is no legal sanctity and there is no legal protection. We don't know who are going to access and how they are going to use this. So for me, I as my knowledge and as part of my research, I won't agree with that. The positive, the positive protection like defensive protection like people biodiversity register, TKDL, is the biggest chance for them to protect this knowledge. Because in my experience, that is not a way to protect this community. They should give at least some kind of power, that positive protection. They have to at least give a say, at least in the resources we are accessing, we are using. At least the people should have the say, the local communities should have the say in. But unfortunately, in our cases, it's not happening. The state is taking the stake in this regards.
Thank you, ma'am. Thank you.
Thank you.
Any more questions, participants? Okay. So shall we move to the next session? Yes. Now I invite Dr. T. Geeta, as Assistant Professor, Department of Chemistry, Vimla College Autonomous Thrissur, to deliver the vote of thanks. Ma'am, over to you. Geeta, ma'am?
Jayashree, I think she left the meeting, I think. Yeah.
Okay. So there is an important announcement. Tomorrow there will be no FDP. The valedictory session will be on 21st August, Monday. There will be an exam based on the sessions conducted. Participants should also fill the feedback forms of all days. This would be mandatory to get the e-certificate, attending the exam and filling the feedback forms. So now can we wind up, sister?
Yes, okay. Thank you, Dr. Chaitanya ma'am, for your nice presentation. And on behalf of Vimla College, I extend my heartfelt thanks to Dr. Chaitanya. Thank you, ma'am. Thank you all.
Yes, thank you. Thank you, ma'am, for that insightful lecture. Now we will meet on Monday. So thank you all. Thank you for your patient listening.